Welcome, everyone. Thank you for joining us today for this webinar covering advertising and technology as it relates to your licensing exam. We will be getting started in just a few minutes here. And if you can hear us, open up your Q&A panel and let us know what state you're from. Again, we'll be giving it just a few more minutes to let more attendees join, and we'll be starting just at the top of the hour. All right, for those of you just joining us, welcome and thank you for being here with us today. We will be getting started with our webinar in just a few minutes here. We will give it a few more minutes to allow more attendees in. In the meantime, if you can open up your Q&A panel and let us know that you can hear us by entering what state you're coming to us from. Again, we'll give this just a few more minutes and we'll be starting close to the top of the hour. All right, thank you everyone for joining us and welcome. Once again, we will be starting our webinar covering advertising and technology as it relates to your licensing exam in just a few minutes here. We'll give just a few more minutes for more attendees to join us. And if you can just confirm that you can hear us by opening up your Q&A panel and entering what state you're coming to us from. We'll give just a few more minutes here. All right, well, we are at the top of the hour. Looks like we've got folks from all over today. I saw quite a few Georgia and California come through. So welcome everyone. And again, thank you so much for joining us today. Just a little housekeeping before we get started. We'll be running a live Q&A at the end of the webinar. So if you have any questions during the presentation, please don't hesitate to type them into the Q&A panel in your Zoom control panel where you typed your state if you shared with us where you're coming from. And if you miss anything, please don't worry. We will be sending around the recording when it's available. We'll be excuse me, we'll be presenting poll questions that you can answer on whatever device you're using to view the webinar from. My name is Jennifer Sterling and I'm an instructional designer at the CE Shop, the leading provider of online real estate education. Today, we are covering advertising and technology as it relates to your licensing exam, presented by Virginia Real Estate Board pre-license instructor, Gail Glassmoyer. Gail comes to us with many years of experience within the real estate industry in Virginia. She's a certified Virginia Real Estate Board pre-license education instructor, and she owns her own career services consultancy, Glassmoyer CMS. Now, without further ado, we will turn it over to Gail.
Thank you very much, Jennifer, and hi, everybody. Hope you are enjoying your day so far. I was hoping that we could start off by figuring out where you are in the course, just to give me an idea. Are you just starting? Are you halfway through? Great. Okay, I see a lot of you have just started. Some of you are almost done. You will definitely find that you're going to find this information useful. Great. Thank you. Okay, so I see that most of you have just started, so very good. We are going to be moving on and get ready to rock and roll. So let's talk about the Federal Trade Commission. They prevent unfair competition and prevent unfair and deceptive practices. They also seek monetary relief for consumers. They'll compile information, conduct investigations, and make reports and legislative recommendations to Congress and to the public. So we are going to be doing audience participation. Yes, that is correct. So we're going to have several questions throughout this time. I'm going to read the question and I will let you answer. 3 brokers, each serve a different part of the city. This is what? You should see a poll come up and I'd like for you all to answer it. Wow. We have a lot of people weighing in. Okay, let's see. So, interesting. I see several of you, most of you have answered C. Okay, but let me tell you, the answer is B. And here's why. This is all part of reading the question well and reading the answers correctly. So 67% of you said legal practice of market allocation. Let me tell you something. Market allocation is not legal, and I'm going to be talking about that in a second. Actually, it is illegal. If you have 3 brokers, and let's say broker A, B, and C, and broker A takes the north part of town, broker B takes the west side of town, and broker C takes the east side of town. If they discuss it jointly, if they all get together and collude or conspire, that is considered market allocation. So while you understood a new market allocation, what happens is it is not a legal practice. It is an illegal practice. So let's talk more about that, shall we? So let's talk about the antitrust acts, because this I think you're going to find really, really important. So the antitrust acts include price fixing, market allocation, group boycotting, and tie-in arrangement. These are all illegal, okay? So price fixing would be exactly what the question, actually, market allocation, let's start with the red one below. That is exactly what that question just showed. A, B, and C all jointly got together and said, hey, you take this area, I'll take this area. That is illegal. You are not allowed to separate the markets, okay? Or you might see a question on the test that says something like, oh, brokerage A is taking the high rises while brokerage B is taking residential. That is also market allocation, and that is illegal. You are not allowed to do that. Price fixing is broker A, B, and C getting together and saying, hey, we're all in the same area. Let's all do like minimum 6%. How's that? So again, they are conspiring or colluding, and the brokerages, the different brokerages, are not allowed to do that. So when it talks about the antitrust laws, they're talking about different brokerages colluding or conspiring. Now, group boycotting would be those 3 different brokerages getting together and say, you know, we don't like XYZ title company. They haven't been very fair to us. Let's all not use them. And they agree not to use them. Well, here's the problem with that. They can actually put them out of business. So that is illegal. Now, tie-in arrangements, a little bit different. It would basically be, let's say you were all my buyers. And I said to you, I will sell you a house, but you have to use my settlement company. I am tying 2 things together. That is illegal. So we've talked about Antitrust Act, but there are a few things that I want to tell you about. So remember, we just talked about market allocation and price fixing. Here's the thing. Let's talk about price fixing first. If a broker in an office said, hey, we are only going to do minimum 5%, is the broker allowed to do that? The answer would be yes. So internally within the office, the broker is allowed to fix what the minimum rate will be, okay? Externally with different brokerages, they are not allowed to do that. So that's where the difference is. Market allocation, if Jim and Tom, two agents, were sitting next to each other and one said, hey, I'm going to take the north side, and the other's like, I'm going to take the south side, is that legal? Yeah, that's fine. They are in the same office. However, as I said, A, B, and C brokerages get together and say, hey, we're splitting up the markets. Not legal. Okay, so internally, okay, externally, not okay. So here's a question I need your help answering. Ready? A property is advertised as being beautifully landscaped. Upon viewing the property, a potential buyer notes, there's grass, a few inexpensive shrubs. This ad is what? I was going to say, I didn't even get the whole question out, and you guys are already answering it. Okay, let's see. It's running neck and neck here. Well, it looks like the biggest part is misrepresentation. However, guess what? The answer would be, I am going to click on this now. Ready? The answer was puffing. So here's the thing. It is completely opinion-based. I could say I have the nicest backyard in the entire neighborhood, but my backyard looks just like everybody else's. So it's really my opinion, and I am just puffing. So the ad is puffing. Very good. It was, when I first saw the answers, it was like everybody was there first. So very good. So regarding misleading advertising, false advertising, these are all the Federal Trade Commission prohibits these things: misleading advertising and false advertising. So here's a question. Select which phrase would be misleading or false advertising. Remember, read the question and read all the answers. Okay. I know there's a lot out there, only a few answers. Think about it logically. So, which phrase could be misleading or false advertising? Okay, about half of you have answered. I'll wait for a little bit more. Very good. Okay, so about 59% of you have had the correct answer. And the correct answer would be electrical system in excellent condition. Why would this be the answer? So when you think about it, take a look at A, B, and C. Those are all opinion-based. It has the most incredible view of the city. This cottage is cozy, or small house but great value. They're all opinion-based. But the electrical system, that could either be in good condition, excellent condition, or bad condition. So that is the only one that could actually be true or false. So very good, guys. You did a good job with that one. Truth in Lending Act. So Truth in Lending Act is also called TILA. It is the true cost of getting a loan, okay? The Truth in Lending Act, let me read this to you. The Truth in Lending Act requires creditors who deal with consumers to disclose information in writing about finance charges and related aspects of credit transaction. So here's the deal. It is the true cost of getting a loan. Must disclose all the information in writing. They have a 3-day right of rescission, and there are exemptions, not for brand new construction or refinancing with an existing lender. So we're going to talk about truth in lending a little further, but there's also RESPA. Know the difference between the two. Truth in Lending Act is the true cost of getting a loan. So you're understanding how much you're going to have to pay every single month. Whereas RESPA has to do with the true cost of closing, and we'll talk about that in a second. So here's a question for you. In which of the following circumstances is the borrower entitled to a 3-business right of rescission? I see, you're good. You are reading the questions and you are reading all the answers. Interesting. So 3-day business right of rescission means that you don't necessarily want the loan. Okay. Most of you have answered. You said financing a home purchase with an FHA loan. Here's the thing. We are going to move to the answer, and the answer is actually nobody picked. It is establishing an open home equity line of credit. So FHA loans are for owner occupancy, which makes them on a dwelling. So again, let's talk a little bit more about truth in lending. We were talking about TILA, truth in lending. There are triggers and disclosures. So if it lists the finance charge or the down payment or the payment amount or the loan amount, they must list everything in the middle. Number of payments, price, amount of payments, due dates of payments, annual percentage rate, and down payment. Or you could look at it like this. Never pet Aunt Dorothy's angry dog. Maybe that'll help you remember. So if you have finance charge, down payment, loan amount, or payment amount, if they are listed, you never pet, which is the price, Aunt, which is the amount of payments, Dorothy, due dates of payments, angry, which is the APR, which is the annual percentage rate, dog, down payment. So if any of those are listed, these also need to be listed as well. So which of the following ads requires that the annual percentage rate be disclosed in the ad? So think about the 2 slides we just saw. Man, you guys are good. Okay, I know only a few of you are in already, but you're doing very well with this question. Going to wait for just a few more to come in. Okay. So very good. And the answer is, and most of you all got this correct, easy monthly payments of $1,000. They listed the money. So very good. That needs to be disclosed in the ad. Very good. So, Real Estate Settlement Procedures Act, also known as RESPA. And I always tell my students, the S in RESPA stands for settlement. So you have TILA, which is the true cost of actually getting a loan, knowing how much you are going to have to pay and understanding what the loan consists of. RESPA is all about settlement. That means going to closing. So just to take a little detour, you have several different, kind of like this is the entire, what am I looking for? This is how real estate works. First thing you do is you get a client. Then you actually do a sales contract. That would be the time when TILA would come in, when your buyer is getting the loan. And then at the end, you would have settlement. So you would have closing. That's where RESPA comes in. So the RESPA is administered by the Consumer Financial Protection Bureau, also known as CFPB, which you'll see in your book. They do certain things. They prohibit kickbacks for referral of settlement services. So it's really your job to get a mortgage guy. So you, as an agent, you want to surround yourself with people. Title company, settlement company, mortgage guy, et cetera, et cetera. You want your set of people. Why? Because it's going to be so much easier. If you suggest to your client, hey, I got people, you can use my mortgage guy, my settlement guy, whatever, you can suggest it, but you are not allowed to say you have to use these services. So it's your job to kind of get these people. However, guess what? You're doing it out of the kindness of your heart and really just to make everything run smoother, because they are not allowed to give you a kickback. They're not allowed to give you anything of value. So just make sure that you understand that. RESPA is really huge on no kickbacks. Seller may not require buyers to use specific title insurance companies. So the buyer must be able to pick their own title company, settlement company, mortgage company. Again, you can suggest, but you are not allowed to say you must, and the seller specifically may not require buyers to use their own companies. Although I will tell you from my own personal experience, after moving here, I had no people, no title company, no mortgage company, whatever. So a lot of the times your client may find that they don't have their own people, so they may use yours, but you just can't make it mandatory. It also prohibits lenders from requiring excessive tax and insurance escrow. They are not allowed to add things in that they either haven't given you or they've made it excessive. So I'm going to just relate this story to selling cars. Dated a guy selling cars, and they used to try to sell people undercoating rust protector of the car. Okay, he proceeded to tell me there is no thing. That is not a thing at all. All they're really trying to do is increase their commission. So it's kind of the same exact thing. RESPA says that lenders can't add fees or things that aren't necessarily real, okay, just to puff up the money that they get. And the lender must notify the borrower if the loan is sold. So here's a question. Which statement is true of a real estate brokerage firm that owns 51% of a mortgage company? And I'm going to tell you, if you haven't seen this in your book, take your best guess. Make sure you read all of them. Okay, only half of you have answered, but you're doing quite well. I'll wait a little bit longer. Okay, well, it looks like we have as many answers as we need. Okay, let me give you the answer. Look at you guys, 83% said D, and that's the correct answer. It is okay for a real estate brokerage firm to own part of a mortgage company as long as they disclose. Disclosure of business relationship between the real estate brokerage and mortgage company must be made. In fact, a lot of times you're going to see when you work at a brokerage, they usually do have a mortgage person on site. And you know what? It's kind of good that they do. Why? Because they're there to help you. So if you are qualifying somebody to see about, how much they can afford, et cetera, it's really nice to actually have somebody from the mortgage company be able to run their background, credit, and make sure they can afford the $600,000 house that they tell you that they can afford. So again, as long as it is disclosed that they are a part owner, you're good to go. Very good. Okay, TILA RESPA Integrated Disclosure, TRID. So here's the deal. I don't know, it was about 12 or so years ago that the entire economy tanked, and the Consumer Financial Protection Bureau said, we really need to make it much, much easier for people to understand all the closing paperwork. So TRID is a combination and a condensed version of two different regulations, TILA and RESPA, also known as the Truth in Lending Act and the Real Estate Settlement Procedures Act. So the TRID rule combines 4 disclosures into 2 easy-to-read documents. And the bottom line is the Consumer Financial Protection Bureau did this to simplify and speed up the mortgage process. For anybody who got a loan maybe about 10, 15 years ago, they had 4 documents. The new documents are the loan estimate and the closing disclosure form. The old ones are the Truth in Lending TIL statement, the good faith estimate, Truth in Lending disclosure, and the HUD-1 statement. So they may or may not ask you which is the one that should replace, but they may ask you what are the 2 that they actually use to replace, and that is the loan estimate and the closing disclosure forms. So the whole thought process behind TRID is to make things easier for the consumer to get a loan and to understand it better. That's really the key. So there are new rules of lending. Consumer Financial Protection Bureau. They like to make sure that you have the ability to pay. So they will verify your financial information, make sure you have sufficient income and assets required. Again, 10, 12 years ago, actually, they were making all kinds of crazy loans. And they were like putting no money down. And sure, bad credit, no problem. We'll give you a loan. So they have obviously put in new rules to make sure that we will never go through, again, what we did 12 years ago. So qualified mortgages prohibit excess upfront points and fees, prohibit toxic features, and toxic features are basically loans that have negative amortization, meaning a loan for which the payments aren't large enough to actually cover the interest in the loan, much less pay off the principal. And they've capped the debt to income ratio. So new rules of lending, making sure everybody is on the same page, making people make sure that they can actually pay off their loans. So unwanted solicitation. Don't we all know that we get that? So we have the Telephone Consumer Protection Act. We have the CAN-SPAM Act and the junk fax prevention. Not that we fax much anymore, but there is still prevention regarding that. And just so you know, both the TCPA, which is the Telephone Consumer Protection Act, and the CAN-SPAM Act addresses faxes as well. And the Junk Fax Prevention Act amended the fax provision for both of the other acts. So here's a question for you. A licensee is calling back open house visitor lists from the company profiles. The licensee should what? Make sure you read all of them. So an open house visitor, that would be an inquiry. Okay, most of you have answered, and you have said, 42% of you said make sure visitors consented in writing. However, the answer is call those who visited within the past 90 days, or you might see it as 3 months in the book. So you might think it would be A, check the do not call registry, but really that's actually the company that does that. So let's talk about this a little bit. The telephone, the TCPS or the TPA regulates interstate soliciting calls, okay? Now, your broker should update the call list every 31 days. And the last 2 bullets, here's the thing. 18 months exemption for existing business relationships. So basically, we're talking about the do not call list, okay? The do not call list, if you have worked with a buyer or you have worked with a seller and you have had a closing and you have an existing relationship, you can call them up to 18 months, okay? However, let's say somebody has come to an open house or they have called you on the phone. That would be considered an inquiry, and you have 90 days to reach out to them, meaning 3 months. So on a call, on a test, when you see the do not call list, okay, you will see either 18 months or 3 months, or you might see it listed as 18 months for an existing business relationship or 90-day for an inquiry, okay? So that's what we're talking about, the do not call list. Canned spam, I'm sorry, this makes me so laugh. So canned spam, we are basically talking about emails. And we know that not only do we get emails, we get texts as well. So here's the deal. The Canned Spam Act establishes requirements for commercial messages, gives recipients the right to have you stop emailing them, and spells out tough penalties for violators. So it could be business to consumer or business to business. There is no B2B exception. So there's a few things you can't do. You cannot use a false or misleading header information. So prohibits misleading regarding sender. You have to say who it's from. Don't use deceptive subject lines. You know they do that all the time. But if you are in real estate, you have certain things that you have to follow. You could definitely not use a deceptive subject line. You have to identify it as being an ad. You must include your physical location. So if you are in Vienna or you are in Elkton, Maryland, you must list that down there. And by the way, just an FYI, if you have a PO box, that is okay as well. You have to tell recipients how to opt out of receiving future email from you, and you actually have to honor the opt-out request promptly. So it's not like when you get around to it, it's within a very short period of time. I think it was 10 days. And monitor what others are doing on your behalf, which is the last bullet. Prohibit delegation of responsibility. So here's the thing. The other day I got an email and I had bought a canvas, I had bought a picture, and they actually had another company, it was called like Site Grubbers or something like that. They were the ones sending me the email for this other company. Here's the thing. If you hire somebody else to do your online email marketing, you are still responsible for things that they send out. So don't think you're not. Faxes, unsolicited advertisements prohibited. No exception for business to business, and exception for established business relationships. So basically you can go ahead, let's say you're a mortgage firm and you're working with the real estate brokerage, you could send them your updated information, schedules, or whatever. However, you do have to have an opt-out so that the business can actually opt out. And you have to opt out the honor, you have to honor the opt-out within 30 days. Advertising and fair housing. You are not allowed to discriminate in any advertising. So let's take a look at our last poll question. Which ad verbiage is legal? Okay, right now we only have 2 answers that people are responding to. 2 of them, you know that they're not. Just going to wait for a few more people to weigh in. Okay, so, wow, very good job. Most of you picked A, and guess what? You would be correct. So, we know you can never put no children allowed, okay? And here's the thing. You can be vague and you could put in an ad, it is near religious institutions. However, you are never allowed to say Christian preferred or close to synagogue or close to a mosque near St. John's Church. No, you're not allowed to do that. The reason why the female roommate is okay is basically if you are in shared space. So let me read this to you. Even though property may be exempt based on being owner occupied 4 units or less, sold by or rented by owner, it may not be advertised using discriminatory advertising. So regarding shared housing, if someone is advertising a shared apartment or house in which tenants share the bathroom, the kitchen, or any other common area, it's okay to express a preference based on sex, but only on sex. So, very good. You did a good job on that question. So, we have some questions now, I believe, Miss Jennifer.
Yes, Gail, we do. So just a reminder for those of you joining us, if you have any questions that you've come up with throughout the presentation, please don't hesitate to put those into that Q&A box. We'll give you just a moment to do that. At the present, we have one question that, that a student has written in, and this is circling back to the discussion about refis. So the question is, generally speaking, this student was doing real estate closings, and some of the refis that she handled also had a 3-day right of rescission. So the question generally is when refis include the right of rescission, and we also have Jill available to add to that if you'd like multiple perspectives.
Yes, I was just going to ask. She would definitely be the person to answer that.
Okay, Jill, can we ask you to, Jill is our national real estate. Jill, I was just giving you a little intro.
Thanks so much.
Absolutely.
Oh, I don't need, a lot of these people have seen me before, so they know I'm just me. But here is my just me answer to that. When we talk about the right of rescission, that is different from what we see in the 3-day time frame that is required when you make a loan application for a new loan. So let me just talk about which loans do get a 3-day right of rescission. It would be refinances, yes. The exception to the refinance getting a 3-day right of rescission would be if it's a refinance with the existing lender. Then they don't need to give them. So the existing lender, I have borrowed from ABC Loan Company, and now my rate seems higher than what I could refinance at. I get the lower rate with my existing lender, and they're not required to give me that 3-day right of rescission on the loan. They might choose to do it anyway, but the truth is a refi with the existing lender does not require it. A refi with a new lender does. The reason that you don't have a 3-day right of rescission on any loan for purchasing a property is this. The right of rescission is from the time that you agree to borrow the money, the time that you accept the offer. Well, you don't accept the offer to borrow the money in a purchase agreement until you go to closing, and then you have a seller who is depending on you to close on that house. So it wouldn't make sense in that case. In a refi, you don't have that problem. In a home equity line of credit, that's an open line of credit, you don't have that issue. So those loans, you have a 3-day period between the time you agree to borrow the money and they fund it, in which you can say, never mind, I don't want to do this. So I hope that answers that question. The other thing that I did start to mention was the other 3 days that it often gets confused with. And that is under Truth in Lending. Once I make a loan application, not once I accept a loan, but once I make a loan application, the lender has 3 days in which to give me the formal loan estimate that does what Gail said, and that expresses all of the terms of the loan, including the APR. So they have 3 days to do that. And that is not a 3-day right of rescission. That's the amount of time that they have to get me that notification so that I compare that loan to other loans.
Wonderful. Thank you, Jill. For those of you who haven't had the pleasure of interacting with Jill, Jill Malloy is one of the national real estate experts we are fortunate enough to have on our team at the CE Shop. So thank you so much for that great explanation, Jill. I hope that that does help answer your question, Jennifer. So going back to a couple more questions about the presentation, Gail, we have a couple of requests to elaborate a little bit on that acronym slide, the Never Pet Aunt Dorothy's Angry Dog. The questions are primarily around context and when that would be used. Can you elaborate just a little bit on the context of when that would be applied?
Actually, I am going to try to go back to that slide. Jill, would you be able to shed more light? It was also, they were asking for this slide and then the dog slide. So can you give a little bit more information on what you were talking about with that?
Sure, I'm glad to. So this slide is addressing advertising with respect to loans. So if someone is advertising a loan, advertising financing, what they are not allowed to do under the TILA, the Truth in Lending Act, is they're not allowed to use any trigger term without making all of the disclosures that are required. So this is speaking to, I'm advertising a loan or financing. Maybe I say something in the ad like, hey, you can buy this house and with only $25,000, you can assume an existing loan. Well, I've already said what the down payment is. And the moment I say that, then I've got to tell you what all of those terms are with respect to the 25,000. Do I mean you're going to be paying for 142 years? Do I mean that if you accept this loan, you're going to be paying 7% interest? What exactly am I talking about here? So what this addresses is what must be disclosed. Oh, and thank you for getting to Dorothy's dog. Aunt Dorothy's dog represents the disclosures, not the triggers. There are only the 4 triggers. But if you use any one of the triggers, then don't make the dog angry.
So basically, the parts in the middle of the screen, if you use the finance chart, the down payment, the payment amount, or the loan amount, then you should not make, it's what's in the middle of that blue screen. The number of payments, the price, the amount of payments, the due dates, and the APR and the down payment. Did I miss
Exactly,
anything
and
in
that's
that,
not
Jill?
about the truth in lending disclosure form. That is more about advertising lending. So when you're advertising loan terms, this is what you conform to.
That's
Shutting
great.
up now.
I hope that that one helps. That was a great explanation, Jill. Thank you so much. I hope that that helps those couple of students' questions. Oh, wonderful. We have confirmation. Glad to help, Danielle.
Great.
Okay, a little bit more general question. Going back to what sort of property, what sort of descriptive terms you can use in an ad. Can ads state that a property is within walking distance of shopping, dining, etc.? We did mention you can't, mention it's next to St. Paul's Cathedral, etc. Other descriptors.
Okay, I'm sorry. I'm not being able to see the question. What was the question again?
Oh, sure. Can ads state that a property is within walking distance of shopping, dining, etc.?
Yes. As long as there's no specifics, the whole thing is you don't want to appear to be discriminatory at all. So if you are just vague and you talk about restaurants and dining areas, even schools, okay. But you can't be, state a religion or, where they talk about the church or the synagogue. So you can't be specific about it, but you can be vague. And yes, you can say that.
Okay. Anything that would trigger one of the protected classes to be either called out, promoted, or discriminated against, right?
Exactly.
Wonderful.
Exactly.
Thank you. Another question. Can you give us an example of misrepresentation versus puffing?
So puffing is opinion-based, where misrepresentation is basically, it's you are saying, oh yeah, there's no leakage, but there is. So you might be misrepresenting the actual facts. Where puffing is more opinion-based, I could literally tell you, oh, there is the nicest water view. I'm going to show you this house with the nicest water view. Well, half the view is the back of a shopping center, but there is a little sliver that is a really, really nice water view. So I would merely be puffing. It's my opinion that it's the nicest water view. And truthfully, it's not all the water view. But puffing is more exaggeration than anything else. Where misrepresentation which would actually be misrepresenting a fact, and that would not be legal. Right.
Absolutely. We do have a follow-up question regarding can you advertise that something is near shopping, dining, et cetera? And this one is a little granular. I think the bigger question is how specific can you get with the descriptions? The student's question is, can you say that it's near a Chinese food restaurant?
Right.
And so maybe if you wouldn't mind elaborating a little bit on the kinds of...
I knew as soon as I said that, somebody was going to ask. So let's just say this, that you really want to stay away from even a hint of being discriminatory. You could say maybe it's near a bevy of ethnic food places. But I wouldn't go as detailed as to say Chinese food or Pakistani food or something like that. You really don't want to kind of drill down into the area, which, it might be a very Chinese area. So I would just stay away from anything that would appear to be discriminatory, but I knew as soon as I said something like that, somebody was going to ask that question. Good for you.
And discriminatory doesn't have to be disclusionary, right? Like in pointing out that this one specific type of food that has a specific ethnic origin, the reason that that might be discriminatory is because it's narrowing the focus, almost saying, so therefore, if you identify with this background, please come here, right? So
Exactly.
that may be part of that confusion. It doesn't have to say, no, you may not. It can also be drawing attention to.
Absolutely. Thank you. Very good point, Jennifer.
All right, well, wonderful. We don't have any more student questions at this point. So we will give students just another second. If you've got any questions, please feel free to type into that question and answer panel. But for the rest of the few minutes that we've got left here, Gail, I'll just open it up to you. And if you have anything else that you'd like to add.
Not really at this time, other than the fact that, there are additional resources if anybody needs help. The customer service email is support@theceshop.com, and the phone number is there. And if you have any questions, feel free to email the instructor at theceshop.com. And we are so glad that you are here with us, and we hope you enjoyed this.
Absolutely wonderful. Thank you, everyone. And as Gail said, we really appreciate you being here and helping us create these resources. I'd like to thank Gail again for joining us today. Your knowledge, expertise, and your willingness to share it with our student community is greatly appreciated. Everyone, please look for an email from us with a link to this webinar recording, and keep an eye out for invites to additional webinars in the near future. Thank you again for joining us today, and we will see you next time.
Thank you.